Hey, good morning. It's Bernard Nomberg with another weekly episode of Nomberg Law Live. And I've got my buddy from Chicago, Joey Vitale. Good morning, Joey. How you doing, bud?
Good, Bernard. How are you? I'm excited to be here.
I am too. I'm looking forward to our discussion this morning. I hope you had a good weekend, a good restful Labor Day weekend. I had a lot of exercise and a lot of football in mine, which is fairly standard for me.
Sure.
But guys, we're gonna talk this morning. Joey's a buddy of mine. We've known each other a couple of years. We've met through online lawyer groups. We've been together at Max Law conferences last couple of years. And Joey, I really appreciate you giving me a few minutes of your time today. And I know we're going to talk about intellectual property. And I know that it is an area for anybody who follows Joey on any kind of social, this is where it's at for Joey, and he's so very good at branding and protecting your brands and those types of things. But Joey, before we really get into that, tell us a little bit about yourself and about your practice.
Sure. So, first of all, I'm so fortunate to have gotten to into that community of lawyers that you and I are both in. Um, Max Law, Legal Minds, the John Fisher's Mastermind. As people who are in business know, it can be really, really hard to run a business. And meeting a community of professionals in my space really just made all the difference. So, Bernard, it really is an honor to be here. It's an honor to just be in this circle of lawyers who are helping each other. And the my actually, I don't think I ever told you this, Bernard, but speaking of John Fisher and kind of my backstory, I was pretty unhappy with the law firm that I was at, and I was looking to apply for a law firm in Chicago before I moved. And so I found this one lawyer who was looking for some help. I looked her up, and she had a podcast. And in that podcast, she referenced John Fisher's book, Power of a System. And that was really my introduction into John Fisher, into this entire group that we're a part of. So this really is kind of all full circle. But I was one of those people who went to law school because I didn't know what I was going to do after I graduated college. And I kind of learned the hard way when I joined that I'm really not meant for the courtroom. So I'm not much of a fighter. I really don't like the conflict of being in the courtroom. And after a couple of years of trying that space out, I learned that there was a different pocket of people who needed legal help that were business owners. And what made me not such a great fit in the courtroom made me a really good fit for helping those business owners. And so for the past 3+ years, I've been helping business owners, especially kind of online business owners, evolve from hobbyist to side hustler to full-time hustler to the CEO of a growing business. And I started my law firm out of this idea of kind of just being a kitchen sink lawyer for those types of business owners. Trying to say, okay, whatever it is that you need help with, let me see what I can do for you. And after helping so many of those business owners, I realized that there are a lot of things that can go wrong in business, and there are a lot of things that business owners can be worried about legally. But trademarks kept coming up as this particular issue that was affecting business owners before they thought it would, and it was something that they really didn't know to plan for. And so because we saw that need and that gap, we decided to really pivot and really promote why trademarks can be such a big issue and how we can help business owners be prepared for those types of risks.
It really sounds like you have not only found your niche, but you've niched down to a place where people are now recognizing what you offer to them. And probably, unlike the improv that I know you were so famous for in college, would you agree with me that business owners really should not be doing improv when it comes to protecting the assets that they're building and that they hold on to? And
Oh
that's
yeah, you're good. You're good, Bernard. So totally. I think there's this kind of concept among business owners of fake it till you make it and kind of just wing it and do things. And when it comes to your brand, that's just something that you want to be very, very mindful of. And the reality is that there are more businesses being created today than ever before. It's in a lot of ways easier than it's ever been to start a healthy, sustainable, growing business. And because of that, there are more businesses that are out there. And when it comes to trademarks and protecting your brand, what that means is that when you pick a name for your business, you have to make sure that you're not infringing on anybody else. And
Julia, I've seen many times where you talk about the concept of owning your brand.
mm-hmm.
I know you give webinars, and I know you have online tools, and we'll get to those parts in just a minute. And I want to give a shout out to our buddy Morris Lilienthal up in Huntsville. He's watching with us. Good morning, Mo. But what does that mean, to own your brand? You create this great idea. You're now going to take it into the marketplace, but then you may have the brains and the ideas of how to do that, but that's not the whole thing.
Yeah.
You don't want your brand to be taken away from you. So talk about that for a minute.
Great question. And let's step back even further than that to kind of what is a brand. So a brand for a business really is, it's beyond just the business name and the slogan and the logo and all of that. All of those are a part of your brand, but your brand is something that sets you apart from the rest. So if you walk down that cereal aisle and you see the different brands of cereal that we all know and love, the Fruit Loops, the Cheerios, whatever, and then you see that just kind of bagged Fruit-O's cereal. So the goal in business to have a brand, it means that you actually, first of all, you have packaging. You're not just a cookie cutter version of what you do, but you are distinctive in the marketplace. When people see that thing, they know what they're getting. And it's easier to think about this in terms of the bigger brands like Coca-Cola, Target, McDonald's, but every single business, even small businesses, have that brand, have that reputation. And when a lot of people think, okay, I need to figure out a business name for what I'm going to do, for when I'm going to name this thing, they tend to run some Google searches. Maybe they see if the domain's available, or they form the LLC in their state, and those are all good things to do. But if you don't run a proper trademark search, then it's very likely that you picked a name that is infringing on another business. And you might be asking, why is that such a big deal? And the reason why that's such a big deal is because it's easier than ever now to actually enforce your trademark rights. So it used to be the case that if someone was infringing on you, you could send them a cease and desist letter, and if they didn't comply, you'd have to drag them into court. And it would get expensive, it would cost a lot of time. But now with, when you think about the internet and how we use the internet by kind of renting space on all of these different online platforms, a lot of our businesses are being built really on the backs of these platforms that we're using. So Facebook, even Google, Yelp reviews, that kind of thing. And all it takes is somebody letting any of those platform owners know that, hey, I have a registered trademark, here it is, and this person is using something that's too close to it. These platforms are kind of like the new courtrooms. And you no longer have to drag somebody to court, you just have to send one of these platform owners your trademark registration, and it can sink your entire business overnight. And unfortunately, it's something that I've seen with a lot of my clients.
Well, let's talk about the hypothetical Joey V's cereal. You've created this new cereal, and we're calling it Joey V's. Now, I haven't seen it in my local grocery store down here. It may be in the Chicago area, but I haven't seen it yet here. But let's use that as our example. That's your new idea. You've got this unique brand of cereal that no one else has made, no one else has come up with. You've done all your research for the last couple of years. You've got a home run in your opinion. And then you're coming to market. And then somebody is coming to you or to your firm. How do I protect my Joey V's awesome new cereal?
Yeah.
What are some things that an entrepreneur or a new business owner is going to want to do?
Yeah. So what I tell my clients is step one is availability, and step two is calling dibs. What I mean by that is
Yeah.
the availability check is doing the Google search, getting the domains, looking for the social media stuff, running that trademark database search, which is free, making sure that the name is similar and it's not too close to anything that's out there.
Mm-hmm.
But once you've confirmed that it's available, you need to be smart because those searches that you run have an immediate expiration date, and somebody could file for a trademark the next day at the federal level, that U.S. registered trademark that allows you to use that circle R symbol. That really makes all of that availability work that you did expired and no longer helpful. It can be really expensive to kind of combat that. So as soon as possible, the way to avoid that is you want to file for your own trademark. And until you get the trademark registration, which tends to take around 6 months minimum, you don't have a lot of confidence that you own it yet. So you just still need to be careful. So what I recommend and what we help our clients do is filing for those trademark applications as proactively as they can, so that they can have those legal dibs on their brand. Because in that example of me with Joey V cereal, the last thing I'd want to have happen is running a search, thinking things are okay, kind of starting to take things to market, and then once it becomes successful, I file for a trademark and it's not accepted, which means that I want to rebrand into something that they will accept. And so all of a sudden I have to pull all of my marketing materials, all of my products, and rebrand. And the cost of a rebrand,
Yeah.
right. And so it really is cost effective to file for these trademarks as quickly as you can, just so that if you need to pivot, you're doing it while that cost of a pivot is still pretty cheap and there's not a lot of brand assets that are out there that you'd have to change.
Such smart advice, guys. We're talking with Joey Vitale out of Chicago. We're talking about how to protect your brand, how to own your brand. You're a business owner and you want to do things the right way to start up. You want to make sure that whatever the name of your company is, whatever you're doing professionally and you're putting out in the marketplace is something that you can own. You don't want to wait too late. I want to welcome PJ, Stephanie, we've got Eric, Stephen, we've got a few other folks from different parts of the country in there. If you have questions or concerns or comments for Joey about this topic, throw it into the comments section and we'll make sure that he sees it and we'll be able to get it to him and hopefully we can talk about whatever it may be related to this. Joey, let's talk about what happens if I have my Joey V's. I'm going to try to get that all protected. But I also see while I'm out there that there's a company called that does also cereal, not the same kind that we're doing, but it's a different but similar name. Let's call it Joey R's, but you're Joey V's. It's very similar. It can be confusing, but it's not the same product, but it's the same area, the same field. How do you deal with that?
So there's never a one-size-fits-all solution to all of this, and I would recommend that you kind of talk to an attorney one-to-one so they know your situation and can tell you what they do. But one option that tends to work well is, instead of trying to be sneaky about it, kind of show everybody your cards. What you can do is you can reach out to that company and say, hey, we're building this thing. We think it's pretty different from what you're doing. And so can we get some type of what we call a coexistence agreement in place where both parties are agreeing that there's not a likelihood of confusion, which is the whole point of trademarks, is to avoid customer confusion. And so the great thing about having that agreement in place is that if you file for your trademark and the trademark office says, no, it's too similar to the other Joey cereal, then you can show them, no, we actually signed a coexistence agreement. We don't think that there's any issue here. And then they'll say, okay, well, if you guys don't think so, we'll allow it to move forward.
Interesting. I guess that also helps to head off problems later down the road when, let's say that Joey V's gets sold to someone else, and then they discover that Joey, I forget the example I gave, Joey V's is out there, then they'd have that documentation to be able to say, no, in fact, we have this agreement that allows us to coexist peacefully, hopefully.
Absolutely. Absolutely. And that's a good point that you make, because a lot of times what our more advanced clients are thinking about is not just protecting their trademarks, but protecting their non-trademarks. And what I mean by that is, let's say, Bernard, that you have a newsletter that you run, and you're super well known for the redfish in your background, so you call it the Redfish newsletter.
That's a good one.
And you don't really want to trademark it. You don't really think that it's that big of a deal. But at the same time, you just kind of don't really want to deal with the hassle of somebody kind of claiming that in the email newsletter space and then telling you that you can't use it. What you can do as kind of like a plan B for kind of like your smaller things like that is, either on your own or with an attorney's help, just monitor the trademark database, so that if anybody ever does file for Redfish newsletter or something like it, then you can reach out and be like, hey, I just want to make sure that you're okay with me using it this way. Here's a document for you to sign just saying that I'm okay using it. If not, I'm going to file a challenge against your application because I was using it first.
Joey, what about those people? And I'm trying to play the mindset of an entrepreneur, a person coming up with something new in the marketplace, and they're on a limited budget. They're using all of their funds, all of their money to create their new idea. And in their mind, I don't have the money to hire an attorney. I don't have the budget for that, which I'm sure is extremely common. Now, that may not be the wisest thing to do, but how do you advise that situation, those types of people who may actually call you and say, I need your advice, but I really can't afford to pay much?
So I usually have two things to say to that. Number one is you're probably fine, meaning that a brand is a very powerful thing, but the purpose of a brand is also for it to be like an empty vessel, meaning that your brand is valuable because of the reputation you've built around it. So as Nike became a more successful company, Nike became a stronger trademark. And so while it is important to be thinking about all of this stuff, recognizing that, when you're just starting, part of the hustle and grit that you just have to deal with is the fact that you may need to make pivots as your business is being validated. The other thing to think about is the fact that, and this isn't to knock other attorneys, but most law firms that are specialized in intellectual property and in helping businesses, because they're law firms and because businesses have to be able to spend quite a bit of money to work with lawyers, a lot of lawyers that work with businesses are used to working with 7, 8, and up figure businesses. And so the recommendations that they give are often catered to those. And the problem with that is that the rules for a business are different at different stages. And those recommendations for a 7, 8 plus figure business aren't as helpful to a 6, 5, 3 figure or not yet, anything figure business. And so it's, when I'm working with this group of emerging business owners, I found that there really is this combination of legal strategy with business strategy for these businesses that is really helpful. And so a lot of times what they really need is kind of a shortcut to resources. And so because of that, when it comes to trademarks, I've been building a resource about trademarks that allow people to take action on it, really understand kind of the context so they can move forward without making some big mistakes.
Well, along those lines, Joey, how can folks reach out to you or get in touch with you or find these resources?
Sure. So I hang out on Facebook and Instagram quite a bit. So you can find me on Facebook here at Joey C. Vitale. My firm's Indie Law. Every week we go live with a different type of a trademark tip. And then on Instagram, you can find me at Joey C. Vitale.
When do you go live? We want to make sure we put all that in the comment section for everybody.
Thank you. It's Tuesday Tuesday at 1 p.m. Central. And if you are a business owner or a personal brand, online entrepreneur looking for help with trademarks, I do have a course that I open once every quarter, and the doors just happen to be open this week. So if you'd like that resource, feel free to reach out and let me know. But the main thing that I'll say when it comes to trademarks are, number one, realize that they are an important thing that your business should do, because you don't want to regret not taking care of this stuff sooner. And second, it's not a matter of just kind of doing the thing. There's kind of these different layers of business setup things that businesses do when they get started. They form the LLC, they get certain contracts, and there's a lot of things, whether it's LegalZoom or an attorney that just has templated contracts and things that you can use, where you just kind of say, I want this, and they give it to you. Trademarks are a little bit more advanced, and so you need to be careful with that stuff, because right now services like LegalZoom are still very much kind of a garbage in, garbage out type of thing, where whatever you fill out in those forms is what they send to the trademark office. And they don't really help you strategize and analyze what's going on so that you're putting your best foot forward.
Joey, I want to make sure before we conclude today that we do put all of that information, your contact information, in our comments section. I want to welcome Charlotte. Good morning, Charlotte, and Rodney, who've just joined us for the last couple of minutes. And we're getting close to concluding our discussion. You know, I'm looking at your shirt, and clearly I recognize the Under Armour symbol that's on your shirt. Everybody does at this point because it's so prevalent, so much out there. And my question to you is, and without looking at your shirt, whenever you see a symbol, whether it's the McDonald's arch or the Coca-Cola cursive connective letters, you know, we all know what those big brands are. Joey, are we always going to see some type of R or C or TM on whatever product that the symbols are put on? Or is that not necessarily the case? And where I'm going with this is, there are lots of people out there who want to make their mark by copying those protected and well-known brands. We've all seen it, like at sporting events. You have the official licensed products that are sold inside the arena and maybe right outside on the grounds. But then go a couple of blocks away, and you've got the unofficial versions of whatever's being sold, the shirts, the hats, the whatevers. Yeah. So my question to you is when you see those brands like that Under Armour symbol, are you always going to see a registration of some sort, or is that not necessarily the case?
Not necessarily. Sometimes you'll see it, sometimes they don't. It's not required for a business with a trademark to include that symbol. You're right, that can make it difficult when there's a potential for buying a knockoff or something. But what's interesting is, and I'm glad that you bring up the stadium example, those symbols are a little bit more different than people realize. So we talked a little bit about applying for that trademark and getting that registration. Only when you get that registration can you use that circle R, but you don't have to do anything to be able to start putting that little TM after your logo, your business name, your slogan, whatever it is. And so if you don't yet have a registration, but you do kind of want to claim ownership of something that you have as a trademark, you can go ahead and put that TM on things. And speaking of those symbols and the stadium, there's a game that I play that my wife hates, which is figure out what in the stadium is actually registered and what isn't. And I'll just go through and I'll be like, that's a TM, so they don't have a registration on it. That's registered, so they own it. So it's once you realize it, it's almost like kind of seeing that arrow in the FedEx logo for the first time. You can't really unsee that after you know it's there.
That's right. That's right. That's good stuff. It's like with me, we've driven Toyota vehicles for many years, and that the Toyota circle with the T, you can spell out, I think, Toyota inside of that emblem. And I didn't realize that until a few years ago. But just such great information, Joey. I really appreciate you spending some time with me, bud. And really, this can be a difficult area of the law for people who really aren't informed, but you break it down so easily. And I know your courses and what you offer to your clients. Just knowing you, I know how well you explain things so easy to deal with these matters, which can be a little stressful at times. So thank you for sharing your knowledge and your expertise today.
Well, thanks, Bernard, for having me. And you're a great friend, an awesome lawyer, and I'm so excited that you're doing these shows because people not only need to be hearing things from all of your guests, but you do such a great job of highlighting different voices that need to be heard.
Well,
So
thank
thank you.
you. I appreciate that. I just got a private message from Mo. He said that his appearance was much better than yours. I don't know if y'all have some kind of beef going on, but just wanted to make you aware of how he feels right now about that. So
Everybody likes Mo. I like Mo too. He's probably
I
right.
like Mo too. Even if I just made that up, I still like Mo. But Joey, thank you again, bud, for your time. And this will conclude us for today's episode of NOMBERG LAW Live, as we try to do each Tuesday at 10 o'clock Central, 8 a.m. Pacific. Interesting conversations with people in their areas of expertise. And Joey, you certainly fit the bill today, bud. Hope you
Well,
have a
thanks
great
again for
rest of
having
your
me.
week.
Bye, everybody.
Take care.